Our discussion today will focus on a recent ruling issued by the Karnataka High Court regarding Twitter's appeal against blocking orders issued by the Ministry of Electronics and Information Technology. In its judgment, the court dismissed Twitter's challenge and criticized the company for not complying with the court's orders. As a result, Twitter was fined 50 lakhs rupees. As a result of this judgment, freedom of expression and speech are undermined. As a result of the court's ruling, the state can exercise unchecked power in taking down content without following proper procedure. It establishes a worrying trend of hindering digital rights and free speech under the pretext of combating false information dissemination. Section 69A on the blocking rules were upheld by the Supreme Court of India in Shreya Singhal versus Union of India, highlighting the importance of procedural safeguards such as recording a reasoned order and informing the intermediary and originator of the blocked content. The precedent, however, is not followed by the recent Karnataka High Court judgment. It suggests that notice to users blocked content is not mandatory, and it suggests that blocking reasons need not be communicated. There is no oversight or recourse for affected entities to challenge these restrictions on free speech as a result of the lack of procedural safeguards. As well, the High Court's observation that Twitter users have access to appropriate remedies and that Twitter cannot be sued for blocking users is criticized. Under the blocking rules, obtaining blocking orders and accessing information can be challenging. Authorities often deny blocking orders to content originators, citing confidentiality requirements, which makes obtaining such orders challenging even the rights to information process. By providing the High Court with blocking orders in sealed covers, there is a lack of transparency in the process, raising concerns about the exercise of state power without sufficient accountability. Article 19.2 of the Constitution enumerates the grounds for limiting freedom of speech. Nonetheless, the High Court's judgment revealed that one of the reasons for blocking content was the potential spread of fake news and misinformation, which may disturb public order and threaten national security. The High Court failed to establish in its verdict that misinformation and fake news were valid grounds for restricting free speech under Article 19.2 and Section 69A, and in order for speech to be deemed prejudicial to public order, a direct link must exist between the speech and the potential threat. Using the rhetoric of fake news to restrict fundamental rights is also reminiscent of using nation's security as a justification for exercise and arbitrary laws. It is considered unconstitutional to block Twitter accounts in their entirety, as doing so restricts the freedom of speech. The Supreme Court ruled in Brijbhushan versus State of Delhi that pre-censorship on freedom of speech is not permitted. When users of online platforms are blocked disproportionately, it can chill their freedom of expression. Thus, Karnataka High Court's judgment compromises procedural safeguards, undermines natural justice principles, and gives the state unfettered power to remove any content it deems unfavorable. The recently amended information technology rules on fact checking, along with this, pose a serious threat to freedom of speech. Hope the information is useful. Thank you very much.